Hello, friends, and welcome back to the Kristen Commentary Podcast. If you're here for part 2, that means you survived the locker room episode. Congratulations. You are officially braver than half of Congress. Last time, we talked about the panic, the tropes, the constitutional lines, and why comfort is not a legal standard. And I said we were going to separate this into 2 episodes because the next topics, sports and youth gender medicine, deserve their own space. They're complicated, they're emotional, and they're places where even people who want to be supportive sometimes get stuck. And honestly, that's fair. These are conversations where we're not just talking about appearances or assumptions, we're talking about fairness, safety, parental rights, medical ethics, and what the Constitution actually requires. These are topics that get twisted into outraged content faster than you can say Title IX. And if we're going to talk about them, we're going to do it with clarity, with evidence, and a little bit of common sense. So if you're here because you want to understand the sports debate without the vibes-based panic, if you're here because you've heard a lot of the noise about youth gender medicine and you want the actual facts, if you're here because you care about fairness, safety, and individual rights for everyone, then you're in the right place. Let's pick up where we left off. Let's talk about what's real, what's constitutional, what's supported by data, and what's just political theater dressed up as concern. Welcome back to Kristen Commentary.
Oh, America, land of the brave, but who will save the ones who crave freedom in a land so divided, where dreams and reality collided?
Like I said in part 1, when anti-trans panic media tells you that people who support trans-inclusive policies don't care about women's safety, I want you to be skeptical. We don't want to live in a country where the government regulates social situations. We should be able to handle those on our own. A lot of anti-trans panic relies on the trope that women are weak and need big government to protect them. They package anti-trans policies as pro-woman, but it's the same old paternalism with new branding. If you're tired of fear-based narratives being sold as pro-woman, you're in the right place. The sports conversation is one of the biggest places that this trope shows up. Like most anti-trans talking points, it's built on assumptions and vibes, not evidence. People get anxious about sports because it's not just about appearance, it's about physical capability, safety, and fairness. And fairness is important. Comfort isn't a right, but fairness is embedded in our Constitution through due process and equal protection. Trans rights advocates care deeply about fairness. Fairness is the foundation of every anti-discrimination law in this country. But if you care about fairness, we have to look at the limitations of this concept from a legal perspective. So let's talk about fairness. The Constitution prohibits discrimination, but it does not require sports to be perfectly fair. Sports are inherently unfair. Genetics gives some athletes massive advantages. Michael Phelps, 6'7", hypermobile joints. These are advantages that no training can replicate. And socioeconomic disparities means that some kids are getting elite training in Olympic-sized facilities and others are not. And courts have never recognized the rights to equal advantages. Natural variation is part of the game. The only line that the law draws is against artificial advantages like doping or falsifying age. So if you think sports should be fairer, I agree. Let's put some of that energy into mobilizing for more equitable access to facilities and training, especially if someone shows talent. Why is it that the only time we want to talk about fairness is when we're trying to exclude people? And just like bathrooms and locker rooms, let's look at what the law already says. Title IX's athletic regulation, Title 34, does not require sex-segregated sports. It says schools may operate separate teams when a sport is competitive or involves bodily contact. May, not must. That means that the government cannot force sex-segregated sports. These decisions belong to schools and sports organizations, and they must consider the rights of all players. The line is the 14th Amendment, due process and individual rights. If you believe that fairness in sports means that everybody's rights are protected, it gives you an easy answer when questions about physical advantage come into play. Yes, on average, males have a 10 to 20% physical advantage over females. But the U.S. does not grant or restrict rights based on averages. Veterans have a higher suicide rate on average, but we don't restrict their gun rights. Police officers have higher rates of domestic abuse, but we don't preemptively curtail their rights. You don't get taxed more if your demographic earns more on average. We protect individual rights, and that same principle applies to trans women in sports. The question becomes, how do we create sports policy based on individual rights instead of statistical averages? That's the question we should be asking. Blanket bans assume that trans women have the same biology as cis men, and that's false. Study after study, including one major study that happened this year comparing thousands of trans women to cis women, shows no significant athletic advantage after 1 to 3 years of hormone therapy. And yes, some trans women don't take hormones. That's why the standard must be individual review, not blanket bans. The 14th Amendment requires due process. That means that inclusion should be the default, unless there is a specific, measurable threat to safety or integrity of the game. If someone shows greater advantage to the point where it's unsafe or unfair, then regulation is reasonable, but it can't be based on sex or gender alone. Sports already has these kinds of standards for age and weight class. If someone is being excluded for safety reasons, they should have the right to appeal. But government-mandated bans violate due process. They're unconstitutional, unscientific, and require a lot of times invasive surveillance to enforce, which harms everyone. If you oppose government overreach, take a look at these trans bans and look at the ways that they violate people's rights and put the government where it doesn't belong. This conversation about sports inevitably brings us into discussions about gender-affirming care for minors, and this is one of the most emotionally charged topics of all. And at the end of the day, it's a question of when and where the government has the right to step in to control family health decisions. Gender-affirming care includes everything ranging from counseling to social transition and, in rare cases, medical interventions. Most youth gender care is non-clinical. No hormones, no puberty blockers, no surgeries. Less than 1% of trans minors receive medical interventions. Meanwhile, far more cis minors receive irreversible procedures like breast augmentation or even circumcision. If the concern is irreversible harm, the logic must be applied consistently across the board, or it becomes a clear case of targeted discrimination. If you want to approach this issue through the facts, let's look at what the Constitution says first. The 14th Amendment guarantees equal protection and due process. That means states cannot restrict health services for trans youth simply because they disapprove of their identity. Parental rights have been upheld as legal precedent for over a century. If parents consent to gender-affirming care, bans violate those rights. The only exception in existing legal precedent is when a treatment poses a proven, significant long-term risk. And if we hold that line, we have to keep gender-affirming care for minors legal. The problem is that the Supreme Court made that more complicated last year in the case U.S. versus Scrimeti. The Supreme Court allowed bans on gender-affirming care for minors based on conceivable risk. That means that basically if we can think of something that can go wrong, we can ban something. That's a very low bar, and it's a standard that is applied very unevenly. Again, cosmetic surgeries, weight loss surgeries, and other irreversible procedures for minors definitely have conceivable risks, but they're still legal. It's a very clear case of identity-based discrimination if we only go after policies for gender-affirming care. We don't want to ban things based on what we can imagine can go wrong, especially when there's so much evidence to the contrary. Gender-affirming care has strong evidence behind it. It reduces suicidality in trans youth by 78% and has extremely low regret rates. There is no evidence of widespread harm, certainly no more than other medical procedures routinely given to minors. The reasonable position is this: medical decisions should be made by doctors, parents, and patients, not politicians. Blanket bans violate individual rights, parental rights, and medical ethics. And we need a higher standard to ban something than a conceivable risk. And whatever principle we choose needs to be applied evenly. Share this with someone who believes in parental rights. We're already seeing parents of trans minors speaking up and fighting back against this. Now, what if parents don't consent to the gender-affirming care? That's a good question, and that deserves to be answered. And once again, we're going to look at existing laws. There are already laws for what happens if a minor wants to do something like go on birth control without a parent's consent. 38 states, including 20 conservative ones, follow the mature minor doctrine, allowing teens to make certain medical decisions like birth control without parental consent. If the logic is that minors can make informed decisions about their bodies when mature enough, what is stopping us from applying that same logic evenly to transgender minors? A lot of times it comes from the fact that people disagree with the very concept of being trans or the idea that trans minors even exist. That doesn't stop these minors from having these rights, especially in states where the mature minor doctrine already exists. The only reasonable justification for banning treatment is if there is a proven, significant, long-term risk. And that evidence simply isn't there in this case. Do you live in a state with the mature minor doctrine? Look at it. It's based on conservative principles of personal responsibility, protecting vulnerable youth, and avoiding government overreach. Does this apply to trans minors? That's the legal question that is still being debated. So here's the deal with trans rights. Whether it's bathrooms, locker rooms, sports, or gender-affirming care for minors, people want to know where the line is. The line must be the Constitution. It must be individual rights. It must be due process. It must be existing legal precedent, data and evidence, not vibes, not tropes, not media outrage, not personal discomfort or disagreement. When you follow the Constitution and the facts, all roads lead to trans inclusion. Anti-trans campaigns are often pushing forced conformity, and that puts everyone's rights at risk. Like, subscribe, comment, and share with like-minded people who value constitutional rights and good faith discussion. I realize that there might be some of you out there who still don't agree with everything I've said in this series, or may still have some questions or concerns, especially on these very emotionally charged topics that I've been discussing. I welcome all good faith inquiries, especially if they are rooted in the Constitution. And remember, at the end of the day, most trans people in America are just regular people who work and pay taxes and who are just trying to live their lives authentically without losing their families or communities. And I want that for them. Welcome to Kristen Commentary.
Oh, America, land of the brave. But who will save the ones who crave freedom in a land so divided, where dreams and reality